public law or private law or both. Then we will talk about the concept that law tort is civil wrong, right? We are referring to the Salmon's definition. Winfield definition is very different from that. And then Frederick Pollock, in his book is available in the public domain, has nicely defined law of tort. Fine? So where do we locate law of tort? Let me see. Do you think law of tort is a part of public law or private law? Yeah? Yeah, good. Let me see both. How? I think it's not working. Let's check that. Yeah. You claim that law of tort is a part of public as well as private. Can you just explain that component? Yeah, fine. See, when you make some argument, we expect you to come out with some proper justification, reasonable justification, isn't it?
In some situations, like as when you before a few days ago, government Bombay High Court also said that without any proper maintenance of road, you cannot collect our tax with the public. It's your liability.
Okay. See, relevant argument supported by relevant facts, isn't it? When you make some argument must be supported by relevant facts. If you make a statement, law of tort is covered under private law as well as public law, can you explain that component? If that is the case, what's the difference between private law and public law? That is also important. If you don't understand the nature and scope of private law and nature and scope of public law, and how come these two categories are related to law of tort. What is public law? Anybody? What is public law? And what is private law? And then the connection of these two concepts to law of tort. Let me see some arguments. I appreciate your observations, but the arguments are not directly related to that answer, right? Of course, law of tort is covered under public law as well as private law. But if you go according to this, the particular definition, according to the structure, right? According to the structure, law of tort is covered under this category, public law. That's it. You don't find that category here. Private law. Private law means Hindu law, Muslim law, right? And contract law is also part of private law, isn't it? See, we have collected this information from internet, right? Internet data available. There is no problem regarding availability of internet data, but there is a problem regarding authenticity and accuracy of the data. We had that discussion with that LLM match yesterday. Right? So never trust internet data. Do you find any problem with this? The diagram, this sketch, right? With respect to only law of tort, we are discussing law of tort, right? According to this particular diagram, this has been collected from internet, public domain, right? You find the law of torts as a part of public law only, right? That is incorrect. So if that is the case, what constitutes public law? Let me see. First year, third year?
First year and second year.
Acha, mix up of function, right, fine. So you expect some response from second year students. They have studied. They have some basic understanding between public law and private law. What is public law? Okay, fine. Public law regulates the interface between the state and people, right? It regulates state and the instrumentalities activities, like you have administrative law is a public law, constitution law is a part of public law, criminal law is also part of public law, right? Because see, all the offences, it is the duty of state to maintain law and order. So therefore, public law covers all the interfaces wherever state is involved. The moment state is involved, it becomes part of public law. And in case state is not involved, it confines to only that the private individuals, like contract. Private law regulates the interface between private individuals, right? Like contract. Contract is a matter of private individuals. A and B entering into some kind of agreement for services or etc. etc. So then it becomes part of private law. So private law regulates relationship between two private parties. Fine, this is the basic, I think, understanding of public law and private law. But when it comes to law of tort, can you explain that component? That law of tort is covered under private law and public law. Law of tort is covered under, that you have to do substantial portion of law of tort is covered under private law. Negligence, right? If somebody has suffered because of negligent act on the part of another person, then there is a liability. If some private individual has trespassed into somebody's property or has created some nuisance, private nuisance, because public nuisance is a crime, that will be covered under crime. Law of crime will regulate that the liability, right? This is, so the substantial part of law of tort is regulated by private law. But when it comes to public component, can you explain some important dimensions of law of tort dealing with public law? Can you illustrate that? Yeah, let me see some arguments. Of course, it is covered under both the categories, private as well as public law. But it is covered under, substantially under private law. So what about the public law component of law of tort? Anybody? Anyone?
Charters.
Yeah?
Charters. Like
Public law, state's involvement. You know, vicarious liability of state.
Sovereign duty of the state.
Vicarious liability of state.
Master and servant, prisoner, agent, employer and employee.
State. Public law means state is involved. Like there is an employee employed by state, the teacher employed by this university, right? This university is a state. Fine? And the person commits some negligent act. There is some action or omission of part of the person, because of that the student is injured. Right? Number one. Number two, see, there is a teacher. You know what is expected from a teacher in case of evaluation? Teacher is supposed to evaluate answer sheet of a particular student, right? Objectively. If there is a teacher, the teacher awards marks only on cover page without checking answers, right? So it will be covered under doctrine of negligence, omission of part of teacher, right? But teacher has been appointed by the state. It means state is vicariously liable. The moment you involve state in any capacity, it becomes a part of public law, right? So therefore, law of tort is covered under private law substantially and partly under public law, right? In case of vicarious liability, negligent act on the part of government employee, etc., etc. Like suppose there is an accident between state government bus and private bus. Because of that, passengers are injured. So there is a liability of public law related issue. Fine? Any doubt regarding that? Okay. Now moving to the next issue, concept. See, whenever you talk about any subjects, I kindly focus 3 W's. Jurisprudence. What is the law? And what ought to be the law? Right? What ought to be the law means limitations. Fine? So let us have some discussion on basic concept of law of tort. Next please. Right? See, you know that law is a tool of control. Fine? We already discussed that. Law is a tool of control, and there is the interface between law and social science. We require law to regulate the interface. Fine? So, see, law of tort is uncodified. Right? You know what is codification and then codification of law of tort? You know something about codification. Law of tort is uncodified law. What is the meaning of the statement of that particular analysis? That law is uncodified. Have you codified law? Yeah. What is the meaning of codification or non-codification of law? Right. We don't have a specific statute called law of tort.
Parliament haven't passed that legislation.
Okay. Codification means formal legislation. Codification means formal legislation, making a law to regulate that activity. Like you have RTA Act, you have Consumer Protection Act, Motor Vehicles Act, right? Then CRPC, CPC, you have specific legislations. So codification deals with formal legislation. Uncodification deals with informal legislation. Like you have some administrative law, it's also part of informal legislation. You don't have any statute called Administrative Act. Same is the case of law of tort, right? Law of tort is a part of private as well as public law. Law of tort is uncodified. We don't have any statute. You know something about that draft bill that was introduced in 1886? You know something about that? Are you aware of some draft introduced by Frederick Pollock in 1886 in India? Any idea? Again, jurisprudence is important, friends. When you read law of tort, read jurisprudential paradigms of law of tort. Codification of law of tort started long back when India was under the control of Britishers. The draft was introduced by Frederick Pollock, Sir Frederick Pollock. The draft is available in the public domain. You can just Google it in Google, he will have the copy of the draft. He used his book in order to come out with a draft on law of tort. Civil wrongs draft, the bill, that draft is available in the public domain, you can examine that. But the draft was not accepted by Indian people, by government of that time. Right? And according to them, law of tort was not suitable. You know, that is a requirement. Different culture, civilization, etc., etc., etc. So the law of tort was not conducive to Indian environment that particular time. So the draft was rejected by the government, rejected by people. He has also appreciated the scholars' contribution in the draft. Right? Yeah, next please. Fine. So let us see that the specific, yeah. Now if you see the Aristotle's contribution, I am referring to that Arthashastra book, the wonderful book. You must read the specific chapters. Right? The book number 3 dealing with civil liability, civil wrongs, trespass, defamation, etc., etc. You can refer to that. Now see that historical perspective is very important when you examine civil wrong or law of tort. You know, 1215, what significance of the year? 1215. Magna Carta, recognizing civil rights. Right? 1410, the grammar school judgment. Right? 1703, Ashley versus White judgment, right? 1861, the landmark judgment by Indian Supreme Court. No judgment, which judgment I am referring to? 1861, a landmark judgment on vicarious liability of the state. And the judgment is related to Government of India Act 1858. Can you name the judgment? Can you name the judgment? A landmark judgment regarding accountability of the state. You know, before that, king can do no wrong was prevalent. King was not accountable to anybody. But it started with some leading judgments where king was also held accountable. And that was the beginning of seeking accountability of the state by Supreme Court judgment. Name the judgment? Anybody? Oriental Navigation Company versus Secretary, right? Secretary Government of India, 1861 judgment of Indian Supreme Court. The judgment is very pertinent from the perspective of vicarious liability. So read that judgment. Then 1868, again a landmark judgment by House of Lords. Which year? Then 1868, before that Court of Appeal, 1866, a landmark judgment talking about strict liability. Railing versus Fletcher contributed to that. Fine. Then you see again 1932 Tokyo versus Stevenson judgment. Right? Hope you remember the judgment related to negligence. Then see series of judgments. Bolumstad 1957. Then 62. 62 means Rajasthan versus Vidyavati. 65 means Raliaram. Which judgment? Raliaram, Kasturilal, vicarious liability, and so on. Right? Then several judgments talking about vicarious liability, right? So if you refer to the Pollock's books, right, the draft is available, you can examine the draft. He has defined all the terms. He has also examined liquidated and unliquidated damages, right? So how far law of tort has been recognized by Indian system of governance? Anybody? Can you list out relevant provisions recognizing law of tort in India? Anyone? Can you list out any provisions of Indian Constitution recognizing law of tort? Article 300, recognizing vicarious liability of the state. Right? Article 21 is relevant for that purpose. Right? Just try to list out relevant provisions recognizing liability, tortious liability of various stakeholders. You have Consumer Protection Law recognizing negligence. Motor Vehicles Act recognizing fault liability, no fault liability. Right? So you should read, because this is not the time to really teach you all these details. And see how far law of tort has been recognized by other jurisdictions. See UK, right? Can you just list out any specific law that has been enacted by UK or US to recognize law of tort? Anyone? Name any statute recognizing one or the other facets of law of tort. Number 1, Crown Proceedings Act 1947 of UK, recognizing vicarious liability. Number 2, Federal Torts Claims Act 1946 by US. In France also the system of direct administrative has been implemented. In Australia, Crown Proceedings Act. So they have enacted various legislations. And in case of Indian context, law of tort is a judge-made law. Do you agree with the statement? Do you think that the law of tort is a judge-made law? Yeah? Just explain that.
So just take an example of Asher versus White and so the court had that if the breach of legal duty has been curtailed, only law of tort to be applied. So that was
Injuria sine damnum, right?
So they established the
Damnum sine injuria. See, law of tort is based on judgments, right? It is also supported by common law system. That is substantial part of law of tort when it comes to Indian context. It does not mean that civil law system has not supported development of law of tort. See, Germany, France, etc., etc. These are civil law countries. They have also recognized law of tort in one or the other manners, like the system of right administrative in France, similar system in other countries. So they have recognized law of tort, right? But of course, when it comes to Indian context, we have recognized law of torts based on judgments. So therefore, law of tort is based on the judgment law, or that it has been created because of judicial interpretation. If I ask you the judgments creating or propounding or examining various doctrines, can you illustrate the judgments creating theories or rules? Anyone? Like negligence, right? Donkey versus Stevenson. Strict liability, Raleigh versus Fletcher. Vicarious liability, the judgment Peninsular Orientation, Peninsular and Oriental Navigation Company judgment 1861. Fine. Several judgments, absolute liability, MC Mehta versus Union of India 1987. Union Carbide judgment. Several judgments talking about that liability. Negligence. You know Boehm's test? Boehm's test. The Boehm firing that institute, right? 1957. So the law of tort has been developed because of judicial interpretation, judicial analysis by the court, right? Several judgments. Okay, next please. Do you read judgments when you discuss law of tort? When you examine law of tort? You know facts regarding the judgment? Rajkot Municipal Corporation versus Manjul Ben Jayanti Lal Nakum. This is 1997 judgment by Supreme Court. Judgment is related to negligence. Judgment is also related to doctrine of forcibility. Have you studied? Do you know something about forcibility? Wagenbound 1, 1961, Wagenbound number 2, 1967, judgment by House of Lords. You know the judgment died because of fall of tree. Right? The government servant died because of fall of tree. and thereafter the person claimed compensation from the state. Matter reached to the Supreme Court. Right? You see the judgment. See, that compensation was claimed on the basis of negligence. That state was negligent to maintain the tree. It was the duty of the state to maintain the tree. Person died because of fall of the tree, right? But see that judgment by Supreme Court. You know something about the judgment? It was not foreseeable which tree will fall when. And the tree was in healthy condition. Tree was in healthy condition. Therefore, state was not held liable because fall of tree was not foreseeable. In case that activity is not foreseeable, harm is not foreseeable, it means there is no negligence. There is no duty of care that exists. So there is a connection between foreseeability and duty of care. This is negligence component of law of tort. If there is some activity that is foreseeable, then there exists a duty of care. Right? So there is a judgment regarding that. So they have examined. See that the mandate of law of tort. You can just read the judgment, right? There is no time because we have limited time. I want to just discuss attributes of law of tort in order to make it very clear. Right? Next please. Now this is the book. I was talking about this book. I think you should read this book. A wonderful book. Book is available in the public domain. Frederick Collar. And this book contains that draft on civil wrongs liability. Drafted in 1886. This is available. You can examine that. Right? And next please. Yeah. It talks about various activities. Right? 11 chapter 72. Next please. Yeah. Let us see definition. I am talking about common cause judgment. What is law? What is tort? What is tort according to you? Tort is a civil wrong. Right? See how this is defined. Has been derived from the tort or twisted or tweaked, etc. etc. It has three categories. You know classification of law of tort. What are the categories? Can you explain classification of law of tort? The categories of law of tort. Anybody? It has three categories. What are the categories? Law of tort. Anyone? What is the classification of law of tort? Yeah.
Law of tort is basically divided into two
categories. Like your negligence, trespass, etc., etc. How to divide these tortious activities on the basis of some specific indicators, parameters. Next please. Reach of duty is applicable to all civil wrongs, whether it is negligence or duty of care or trespass or everything. Right? See, there is a duty, right? Duty has not been respected. The classification of law of tort. Next please.
Against person, against economic interest.
I'll show it to you. I think you don't have basic clarity about that. I'll show the classification. Before that, let us have some, right? Now this has been defined by Section 2 of Indian Limitations Act, right? What is tort? Tort means a civil wrong which is not exclusively a breach of contract or breach of trust, right? Means tort is a civil wrong which is very different from breach of contract, breach of trust or any other civil wrong. Right? So that is a very simple definition. Now see, if you really examine law of tort, a kind of civil wrong, and civil wrong is very different from criminal wrong. Right? Let us see some definitions. I will talk about the classification next please. Classification because right now see that I am going to discuss three important definitions of law of tort. The concept of tort. Number one, Salmon. Right? John William Salmon. Number two, Percy Winfield. Number three, Frederick Pollard. And I am going to compare it in order to make it very clear what is the concept of law of tort. Right? Now see, can you see the definition? If I ask you to really list out important parameters of the definition by Salmon, see number one, tort is a civil wrong. Number one is tort is a civil wrong, right? And the remedy is common law. Again, what is the remedy? Tort is a civil wrong, and what is the remedy? Unliquidated damages. And then see third one, that civil wrong is very different from breach of contract or breach of trust. See, that is the definition. If that is the case, how are we going to define that the civil wrong? That is the problem. So the definition is very limited, right? This definition is very, very limited. It has a narrow sense. Now see the second definition, the clerk and the lien cell. Same repetition again, right? The wrong independent of contract. It means that tort is a civil wrong which is very different from contract. Fine. Of course, contract is also related to civil wrong, but contract deals with different nuances. Like contract deals with liquidated damages. It deals with two private parties. There exists a contract between two private parties, but in case of civil wrong of that nature, there is no agreement. There is no privity between the parties. Right. Now see the next definition. So just compare salmon, number one. Number two, that passing in field. Number three, that Frederick Pollock. And I want your inputs. Which one is the best suitable definition of tort as on date? Yeah, right, please. Yeah, see this Rajkot Municipal Corporation has referred to passing in field, right? And passing in field has also contributed that discussion between law of tort or law of torts, right? The pigeonhole theory, etc., etc. Now see this Winfield, according to Winfield, tortious liability arises from a breach of duty now, right? See, Salmon has referred to only civil wrong, but Winfield has extended the definition. Now he has used the term breach of duty, right? That tort arises out of breach of duty. See that extension, right? Primarily fixed by law. Which law? Primary fixed by the law. Which law? Because law of tort is uncodified. We don't have any law. Which law are we referring to? Yeah? Law means codified as well as uncodified law. Like negligence. If there is no law, but then the doctrine of negligence has been appreciated, has been recognized by the judiciary. Yes, several judgments recognizing negligence, right? So law means right, the statutory as well as non-statutory law, formal law as well as non-informal. Two, the duty is towards persons generally, and third one is, see, number one is breach of duty, fixed by the law. Number two, duty towards person, and third one is the consequences in case of breach of the duty of care, right? So see the deviation, right? Another next one is Frederick Pollock. Yeah, let us see. Next please. Now see this. And I want your attention to this particular definition. Let me see. Don't you see the change? Change from Salmon, change from Percy Winfield, and see this definition. Frederick Pollock has referred to act or omission, right? Salmon has not referred to act or omission. Percy Winfield has referred to only that component. The component is breach of duty. But he has made it very clear that breach of duty is related to action or omission. So therefore, law of tort deals with action or omission on the part of defendant. I hope you understand that this is not required to be explained, right? Plaintiff means the person who has suffered some harm. Defendant means the person who has caused some harm to plaintiff. Fine? That is the relationship. Now see this. I think this is the most important component of law of tort in our context. So you must be very sure about that. Because the modern concept of law of tort is based on this definition. Frederick Pollock's definition. Even if you talk about negligence, what is negligence? Action or omission. Fine? Okay now. Is an act or omission, right? Not merely breach of duty arising out of personal relationship. Again, act or omission which are not related to breach of contract, right? And harm suffered by the person. They are the following ways. Frederick Pollock, number one, breach of duty. Breach of duty through action or omission. Right? And then harm suffered by the person. He has referred to the harm suffered by the person through following ways. And if there is a lawful justification, there is no liability. I am talking about defenses. If defenses are available, then there can't be a liability, because there are some specific defenses which are available in case of negligence, like act of God, consent, etc., etc. If these defenses are available, there can't be any liability. But if there is no defense available, then there is a liability. This is, I think, a simple analysis of the term tort. Right? Yeah, next please. You can see that also because they will read it. Fine. Yeah. Now see, law of tort according to the judgment. Can you just examine that? And I am going to ask you to list out important parameters of concept of tort. How to identify the features of tort in general context. Now see, a wrong committed upon the person or property. And this is, friends, this is related to classification of tort. Right? See, number one, torts affecting a person. Number two, torts affecting property. Number three, torts affecting property and person both. So you have this classification of torts according to the Frederick Pollock, according to several judgments. So the classification of law of tort by Frederick Pollock has been accepted by Supreme Court also. Now see the judgment. Rajkot Municipal Corporation Mann. They have accepted that classification. And if you read that Ratanlal Dheerajlal book, they have also accepted that classification of law of tort. It has three categories: torts affecting person, torts affecting property, torts affecting property and person both. This is the classification. Otherwise, there is no classification other than the particular broad classification. If you see the literature available, they have classified this classification into various categories like negligent act, sick liability, etc., etc. So that is not proper classification. You should go by this classification, right? Fine. Now see the important parameters. Direct invasion of somebody's legal right. It means there is a legal right, there is a remedy. We talk about that Ashok versus White judgment. There was no right. There was an entitlement. There was legal right. Legal right was breached. Person was not allowed to vote. Right? Person did not suffer any harm because the person in whose favor he wanted to vote, the person won the election. Right? So there was a direct invasion. Interaction again of some public duty and the violation of public obligations. So these activities are covered under law of tort. Right? Private obligations are covered, public duty is a violation, the violation of legal right. So all these activities are covered under law of tort. Now, right, OCS activity may happen because of breach of legal right, because of breach of public duty, or maybe some violation of some private obligations. Right? Because one neighbor is required to take care of another neighbor. That is, I think, the requirement. Next, please. Okay, friends, now, right? Independent tort features, joint tort features, all these things must have been explained to you. I don't want to discuss that. Right? Malfeasance, misfeasance or non-feasance. Next, please. Now, what are the sources of law of tort? If I ask you, what are the sources of law of tort? Number one, judgments. Precedents or judgments. Judgments are delivered by the judiciary, by House of Lords, UK Supreme Court, Indian Supreme Court, High Court, Court of Appeal, etc., etc. Fine? Number one. And that is the main source of law of tort. Number two, constitutional law. Number three, primary and secondary law. Law of tort? Yeah, let me see. Yeah. Criminal law is a part of law of tort. Is it so? Do you consider law of tort includes criminal law? Do you think negligence includes mental element? See, there is a...
Sorry.
Yeah. Do you think negligence includes mental element? Intention is relevant in case of negligence? Right. What is the difference between simple negligence and gross negligence? And criminal negligence? And composite negligence? and contributory negligence? My dear friends, you need to clarify your basic concepts. Fine. And I make it very clear, intention is not relevant for the purpose of negligent act. You know, rash and negligent act. Fine. Rash and negligent act does not include intention. The moment you include intention, it becomes crime. Right, I tell you, several judgments decided by Supreme Court. Jagar Khan judgment. The person was homeopathic doctor. He delivered some medicine to a lady. Lady consumed the medicine. She suffered from some serious sickness. That 20 ml medicine was consumed. Some dhatura was consumed by the lady. The lady died because of consumption. Initially, the person was prosecuted for rash and negligent act. Right? And then it was also considered case of murder, etc., etc. Finally, when the matter was decided by Supreme Court held that liability under rash and negligent act. The doctor did not have intention to kill the person. In second case, there was a dispute between two neighbors regarding parking of the vehicle. One neighbor was objecting to parking of the vehicle. Right? Thereafter, there was a fight between these people. Right? And this person, one neighbor who complained against the another neighbor regarding the dispute. Thereafter, some time, the person who had filed the complaint was hit by this neighbor on wrong side of the road. Initially, he was prosecuted for rash and negligent act, but High Court and Supreme Court converted that the crime from rash and negligent act to murder. You know why? Because the person had the intention to kill the person. Because there was a fight, there was a dispute. So in that case, you must understand, intention, mens rea is not relevant in case of gross negligence. Mens rea is not relevant in case of criminal negligence also. Several judgments on this particular issue. See, whenever you examine negligence, kindly read all these relevant judgments, try to examine the relevance of intention, mens rea or ex rea. Fine, so much of literature available. So don't be misled by all these judgments. I tell you, there are some judgments. Jacob Matthew judgment, right? That Martin D'Souza judgment of 2009, you know, Jacob Matthew 2005 judgment. Judgment is related to criminal liability of doctors. Then Martin D'Souza judgment of 2009. That was the several judgments thereafter. See, Martin D'Souza judgment, right? They also accepted the fact that intention is relevant in case of criminal negligence. That is incorrect. Same has been repeated by the judgment of 2009 Martin D'Souza, that intention is relevant in case of negligence. So that judgment is also incorrect. So you should not be misled by all these judgments and take it for granted that intention is not relevant in case of gross negligence. Negligence means careless act. If you talk about subjective theory, objective theory, then you will be in a position to appreciate that. But because of time constraint, we can't discuss that. But of course, we'll discuss that component. Fine. Now see, I think you can skip that. So tort or torts, vision or theory is not so important here. Let me see. Yes, please. Next, please. Next. Next, please. Right. Now let me see. I hope you have some basic understanding of law of tort. Now I am going to summarize, recapitulate vital parameters of law of tort, and I think that will really enrich your understanding. Fine. Basic attributes of law of tort. Number one is dynamic. Do you agree with me? Yes. That law of tort is very dynamic. Can you explain that dynamism on the part of law of tort? Anyone? Law of tort is very dynamic.
It is not restricted to a book, like it is evolving day by day.
Right. See, let us examine negligence. Fine. Negligence started from the judgment of 1932, Donkey versus Stevenson. The neighbor is required to take care of another neighbor. The neighborhood principle was recognized by, right? Thereafter you see that Nengi vs. Stevenson judgment is related to protect liability. That time it was considered a case of negligence, but as of date you have consumer protection law. We have codified subsequent judgments. Now we talk about res ipsa locata. We also talk about contributing negligence, composite negligence, comparative negligence. So negligence has been developed because of judicial announcements. So comparative negligence is considered, is recognized. So you have to you can relate it to maybe nuisance, primary victim, secondary victim, etc., etc. So it is very dynamic. Fine. Number two, common law system is based on common law system, because law of tort has been recognized and then promoted by judgments. Common law system, you have several judgments propounding new theory, new dimensions of tortious liability, right? Absolute liability. Do you think strict liability is a tort or absolute liability is a tort? Let me see your understanding of law of tort. Absolute liability is a tort or not? Do you think vicarious liability is a tort or not? Tort means independent tort. This will also reflect your understanding, that you have some understanding of law of tort. See, understanding law of tort is okay. Application is certain component. You know negligence, right? So if you know negligence, you would be in a better position to determine whether person is negligent or not, right? Yeah. Whether strict liability is a tort or not, vicarious liability is a tort or not. So it's a case of absolute liability. Let me see some inputs. And that is also a reflection of your understanding of the concept of tort. Anyone?
Sir, vicarious liability is within IC, but absolute and strict are
Torts.
tort.
Tort or torts, it does not make any difference. Labor law, company law, administrative law. Fine. So according to you, absolute liability is a tort. Strict liability is a tort. My dear friends, you have to update your understanding. Fine. See, liability, it deals with liability. Liability, number one, liability. Liability means liability arises because of breach of duty, because of violation of a legal right, because of violation of some private obligations. I am referring to Frederick Pollock analysis, quoted by that judgment of 1997, Rajkot Municipal Corporation judgment. Right? So, liability has two categories, primary liability and secondary liability. So, therefore, it becomes very important to understand fundamentals. Yesterday, we had some discussion on contract of employment, contract of service, right? So, if you want to really examine strict liability, absolute liability, vicarious liability, you must be in a position to appreciate liability doctrine. And liability has two categories, primary liability and secondary liability. Can you explain what is primary liability and secondary liability? Anyone? Last bench, yeah, our good friend, busy with mobile phones. What is primary liability and what is secondary liability? We talk about unliquidated damages, right? Yeah. Yes. What is primary liability and what is secondary liability? Primary evidence, primary research, secondary research. Now, if that is the case, see, our discussion is confined to only law of tort. Law of tort is related to unliquidated damages. It deals with liability arising out of tortious activity. So, what is this liability all about? Number one is primary liability. What is primary liability?
The party which is directly liable for
Directly liable. Okay. What is secondary liability? If that is the case, secondary liability. See friends, in case of primary liability, the person who has committed wrongful action is liable for that wrongful activity, right? In case of secondary liability, one person is held liable for wrongful action of another person, like vicarious liability, right? That employer is held liable because of wrongful action on the part of employee. State is liable on the part of, because of wrongful action on the part of employee or government servant, right? So is the case of the principal and agent. So is the case of partnership. So is the case of companies, the managing director, etc., etc. Right? So secondary liability arises because of some general relationship. So vicarious liability is covered under secondary liability. The person is held liable not for committing a wrongful action, but because of somebody else wrongful action. Employer is held liable. So just take care of that liability, strict liability. Just find out. Do some research whether strict liability is an independent tort, absolute liability is independent tort, and vicarious liability as independent tort. Just do some research and find out. You need to really clarify your basics. That is the real problem, I tell you. Okay, fine. Now see, number one is dynamic, number two common law, number three uncodified law. The third characteristics of law of tort is that law of tort is uncodified. Do you buy the argument? Uncodified law.
In India, sir,
In India we don't have any law. Fine, we don't have any specific law to regulate negligence, any specific law to regulate other parameters, law of tort. Fine, we don't have any formal legislation like RTI Act, Lokpal, etc., etc. We have formal legislations recognizing all these activities. Fine, codified. So law of tort is uncodified. This is regulated by some facets, and negligence is the most important facet of law of tort as on date. So you must know everything regarding negligence. Forget about other things. Of course, nuisance is also important, but trespass, right? Negligence is also covered under civil law as well as criminal law. So we are concerned with civil liability of the parties. So therefore, law of tort is related to civil liability. Criminal liability is not covered under law of tort. Criminal negligence is not covered under law of tort. Fine. Gross negligence is also not covered under law of tort because it has criminal liability. Fine. Okay. The fourth one is law of tort is covered under private as well as public law. We have already discussed that component. Fine. So what about fifth one? Law of tort deals with civil wrongs, specific civil wrongs. And the civil wrongs are very different from other civil wrongs like breach of contract, breach of trust, right? Other parameters. So that is very, very different. Yeah. Now somebody was talking about unliquidated damages. Yeah, can you explain that? Because law of tort deals with unliquidated damages. Now what is the distinction between damage and damages? Like worker, employee, etc., etc. Yeah.
damages are relief and damages harm.
Damage is the loss. Damages are the compensation or some sort of relief that is being given for the damage.
Okay, damages means the loss determined by the court. Take into consideration pecuniary losses and non-pecuniary losses suffered by the parties. Fine. Damage means that compensation claimed by the victim, by the plaintiff. That's the basic difference between these two components. Fine. What is unliquidated damages means? Undetermined damages. See, you have predetermined damage, like there is a breach of contract, the party shall pay 10 lakh rupees, etc., etc. But what happens in case of law of tort? Like suppose there is an accident involving two parties. The victim is suffered because of that accident. So victim is required to prove his claims. And what is the proof? Lies on the victim to prove that he suffered because of breach of the duty of care, right? And then he suffered from pecuniary loss like loss of salary, loss of income, or maybe that medical treatment because of accident. In case of non-pecuniary losses, suffering, pains, etc., etc., right? Discomfort, inconvenience, hardships. So in case of pecuniary losses, it is very determined. But in case of non-pecuniary losses, loss of life, etc., there is a problem. And court has the discretion to determine quantum of compensation in case of non-pecuniary losses. So when we talk about unliquidated damages means we talk about pecuniary as well as non-pecuniary losses suffered by the victim, right? And what about seventh one? That is the sole basis of law of tort, right? What is the basis of law of tort? Seventh one. Let me see, your good friend. Yeah. What is seventh principle? Seventh point number 7, item number 7. And law of tort is based on that. 100% is not possible. Court has accepted the fact that 100% is not possible. You can't compensate loss of feelings, loss of life, etc., etc. Right, some leg is amputated, compensation is awarded. Whether compensation can substitute leg, whether compensation can substitute some body part, can restore the life of the person in case of death of the person. So what is the basis of the 7, point number 7? What is the mandate of law of tort? Point number 7 is related to that. What is the mandate of law of tort? Yes, friend. Next. What are the relevance of restitution regarding law of tort? Oh my God. Yeah, let me see. Yeah, one good friend, last. Yes. Law of tort deals with restitution, right? Restoration to original condition, original health, original status. So law of tort deals with the restitution. The mandate of law of tort is to restitute, restore the state of the person. Right? Therefore, paying compensation is an act of restitution. Right? You pay the compensation to the person in order to compensate the harm suffered by the person. But 100% restitution is not possible. Supreme Court has accepted that. So this is also related to unliquidated damages. Right? So mandate of law of tort is to restitute the parties for harm suffered, injury suffered by the person or loss suffered by the parties. Fine, that's the basic objective. And what about 8 point? Item number 8. Civil remedy before civil court. Right? You have to file a suit before civil court in order to claim benefits. You may approach, example like in case of Motor Vehicles Act, MACT. In case of negligence related issues covered under Consumer Protection Act, right, 2019. Fine, Consumer Commission, District Commission, State Commission, National Commission, right. So the remedies are available in the form of unliquidated damages before civil court or a tribunal. No remedies available before a criminal court. See, the subject matter jurisdiction of law of tort is civil in nature. Civil take care of the specific subject matter jurisdiction. Fine. So that is, I think, very important component of law of tort. So any doubt regarding this, the basic attributes? Anyone? Any clarification is required? I hope everything is clear. So you must be in the position to really appreciate. See, this is the face of a tort. Dynamic, based on judgment law, uncodified, dealing with public and private both, specific civil wrongs, unliquidated damages, restitution, etc., etc. Right? Okay, fine. Now that next please. Have you studied? Yeah, now see this classification. I am talking about that classification. According to Frederick Pollock, it has 3 categories. Torts affecting person, torts affecting property, torts affecting property and person both. Now but you have separate classification. That is also appreciated by Supreme Court in several judgments. Do you buy that argument? See the classification. This classification by J. Lakshmi short one. Do you buy this argument? The number 1 is intentional tort. Intention is irrelevant. Number 2, negligent tort. Number 3, strict liability tort. Do you agree with this classification? Let me see. See, negligent act may be covered under strict liability. Right? Intentional act like you have trespass, malicious prosecution, right? Battery, assault, etc., etc. In such cases, intention is irrelevant. Motive is not so relevant in case of law of tort. If motive is good, right? Then there is no liability. That is not relevant. Intention or all these things are objectives or intention, motives are not relevant in some cases. But may be relevant in case of trespass, may be relevant in case of malicious prosecution, may be relevant in case of that assault or battery as a case may be. So there are some specific civil wrongs where intention is relevant. But not in all the cases, like negligence does not involve any kind of intention. The moment it involves intention, it becomes crime. Fine. So I think this is not acceptable. But if you see literature, public domain, in the public domain, you have that. So don't simply borrow it, right? Use your discretion. Next please. Fine. Yeah, now see, I was talking about this. Frederick Pollard, then the judgment by Rajkot, etc., etc. Right? Now see, person wrongs, right? See subcategories. Number 2, property, subcategories. Number 3, group C, torts affecting persons and property, like nuisance and negligence is covered under the last category. It affects property as well as persons. Fine. So this is, I think, the appropriate classification of a law of tort or tortious action or activities. Yeah, next please. Yeah. Any problem? See again, I have collected this picture from internet, and internet very dangerous. Parents of internet data, never trust. Do you find any problem with this picture? See, we have discussed nature of law of tort, right? We know classification of law of tort. We know nature and scope of law of tort. Do you find any problem with this? Yeah, let me see some observations. And kindly raise your hand if you have some specific observation regarding that. Yeah. Starting from anybody, fault, type of injury. Yeah, let me see one observation.
Type of injury is like injury to both the non-present.
Yeah, type of injury.
Property and person both are non-present.
Okay, third category is missing. Fine, good. Then, no problem at all. So let us talk about first the fault. Wait, is any problem with the first category fault? Number 1, strict liability. Number 2, gross negligence. Number 3, negligence. And next is intention. What is missing? No fault liability. Right? So law of tort deals with fault liability as well as no fault liability. So strict liability is a no fault liability. Strict liability has 2 categories. Number 1, primary strict liability. Number 2, secondary strict liability. Kindly do some research and find out, because law of tort is very dynamic. Don't be misled by some kind of misconceptions created by somebody. Right? So number 1 is fault. So law of tort deals with fault liability as well as no fault liability. Fine? Yeah, of course gross negligence is very different thing. Number 2, injury we already discussed. What about damages? What about damages? Compensatory and punitive damages. What about exemplary damages? What about nominal damages? Right? Like Ashby versus White, that judgment is related to nominal damage. Violation of legal right, no harm suffered. So the court has a discretion to award nominal damage in such cases. But in case of exemplary damages affecting public at large, if somebody has obstructed a public highway and because of that somebody has suffered, so there is every possibility of awarding exemplary damages, right? So this classification is not complete with compensatory. The basic objective of law of tort is to compensate, to restitute, right? Punitive is okay, loss, wages. So this is a classification of pecuniary as well as non-pecuniary damages. Expenses, wages, pain and suffering. Pain and suffering is part of non-pecuniary losses. Fine. So this is incomplete. But what about excuses? Excuses means lawful justifications according to Frederick Pollard. If you have lawful justification, there is no liability. Right? If you don't have lawful justification means defense is available. Right? So what is the negligence of plaintiff? What is that? Yeah. Negligence of plaintiff. How would you analyze that? Do you think negligence of plaintiff is a defense available? And how would you define that term? That's the appropriate term that is supposed to be used by a scholar when he refers to that specific term. Right? Negligence of plaintiff. What are the terms generally used by scholars when we refer to that? Do you know something about contributory negligence? Do you think contributory negligence is an absolute defense? Yeah?
But not complete.
Contributory negligence, last opportunity rule, isn't it? And you know something about comparative negligence doctrine? Comparative negligence. Comparative negligence has two components. First is that if the victim has caused injury or the victim is responsible for that the contributory negligence or that victim is or the plaintiff is responsible for his own fault or injury up to 50%, then there is a liability to pay compensation. In case it exceeds 50%, no compensation. Fine. Initially, contributory negligence was considered as an absolute defense. Thereafter, the element of last opportunity rule was introduced. Right now, we have comparative negligence, and the second component of comparative negligence is that it may be any amount of negligence, any amount of the failure or action or omission on the part of plaintiff. That will be 99%, so plaintiff is entitled to 1% compensation. Forget about the 50% limit, right? So that is composite negligence second test. That is very important. So you must know the latest development regarding composite negligence, right? So that compensation shall be reduced in accordance with action or omission on the part of plaintiff. Fine. So do you think contributory negligence includes negligence? If I ask you. Do you think contributory negligence includes negligence? Yeah? Very tricky question, not so simple. And this is also related to negligence and contributory negligence. See, in case of negligence, burden of proof lies on the defendant or plaintiff. In case of, have you studied negligence? Not yet? Have you studied negligence? You know something about negligence? So what is the distinction between negligence and contributory negligence? Anybody? Anyone? Contributory negligence and negligence. Let me see. On the basis of specific parameters.
So
Number one is,
So in contributory negligence, both defendant and plaintiff had recklessly behaved.
Okay. Next. See, number one is burden of proof. In case of negligence, burden of proof lies on plaintiff to prove his claims. In case of contributory negligence, burden of proof shifts on defendant. He has to prove that contributory negligence, right? And see that liability and other factors. But when it comes to the question whether contributory negligence includes negligence or not, let me see your understanding. Contributory negligence includes negligence or not? Just find out. It does not. Right? Just find out the rationale. Fine. So this is, I think, the defenses. See, there are general defenses which are available. There are specific defenses which are available. General defenses like act of God, consent, contributory negligence. Of course, it was considered the defense at some point of time. Fine. Several general defenses which are available. But there are some specific defenses which are available in each case, like negligence. Consent is a defense, absolute defense available, right? Then act of God may be included in any category. Right? So whenever you examine any wrongful action, kindly examine the nature and scope of that wrongful action and what are the defenses available. See, defenses are available to defend and to counter claim that claims raised by the plaintiff. Right? So defenses are available on the part of defendant to counter the claims filed by the plaintiff or victim as the case may be. Fine. So this is, I think you have to see, public wrongs are beyond the scope of law of tort. Public wrongs are considered as crime, like public nuisance is not covered under law of tort. Private nuisance is covered. Now see this, right? Now I'm referring to King's Bench division judgment. Or digs a ditch on the public road, right? Causing inconvenience to public at large. This is part of public nuisance, and public nuisance is an offence. It's a crime. And see, if somebody is affected by that, it becomes part of private nuisance. So you have to really understand public nuisance and private nuisance. Simple negligence and gross negligence. Right? Yeah, next please. Okay friends, and I think, see, let's read the judgment. Wonderful judgment. Right? Have you examined the judgment? This MCD versus 1966 judgment of Supreme Court. MCD versus Subhagyamanti judgment. Yeah, res is a locator. And omission on the part of MCD to maintain that clock tower. Have you also examined the judgment of, I think the 1999, that MCD versus Sushila Devi judgment? Yeah? 1990. No. Sushila Devi is different judgment. Of course, the judgment is related to Delhi. See, in case of Subhagyamanti, right, the person died because people died because of fall of clock tower. Clock tower was required to be maintained by MCD Delhi. Right? They did not maintain it. By applying the doctrine of res ipsa loquitur, the party is not held. Right? MCD was held liable. But see the contrast between 1997 judgment of Municipal Corporation Rajkot and MCD versus Sushila Devi. In case of Rajkot, the person died because of fall of live tree. In case of Sushila Devi, MCD versus Sushila Devi, 1999 judgment, the person died because of fall of dead tree. In first case, no liability. In second case, there was a liability. So compare these judgments to understand that negligent act. Right? The person died because of fall of dead tree. So there was a liability. Person died because of fall of live tree, no liability because that was not foreseeable. Which tree will fall when? So I think these are the larger issues which are required to be examined by you. Fine? So I think, this is see the judgment, you can examine all parameters. Negligence, this is regarding negligence. Fine? Yeah. So we have time up to what? Time up now?
Yes, sir.
Okay, so friends, I would advise you, law of tort is very interesting subject. Right? It deals with our routine. Right?